We'll have a brief response from
Yeah, it's very brief. I mean, I'm with you, Helgi. Let's, if I want to hear from your clients and others what those Title I bases are. Okay, it's not my preferred way of going because, to be quite honest with you, again, you want to keep going down the road of Title I, everybody's going to run back to court, and we're going to be in the same position we are now. You may absolutely be right that all those things I ticked off have some jurisdictional hook somewhere. And it wouldn't be wrong for the commission to go down that road. But my fear is that in the meantime, there's an awful lot of regulatory uncertainty, particularly for consumers, about whether they're going to be protected or not. So the third way is an interesting way, and maybe the way the FCC goes. But I do think that Title II is a firmer, if you give a good reasoned explanation for why you're going back to the way it was for 75 years, as long as they do that, they're on much firmer legal ground. I'm not going to argue with you on the procedural infirmities because, quite honestly, I agree with you. All right, I think public knowledge was on the complaint that Free Press bought. I think we worked with the hand we were dealt. There was no reclassification, wasn't even on the table, right? We worked with the hand that we were dealt. We had somebody who wanted to file a complaint because your client was acting badly. Whether the case was resolved in the most sound procedural way, I have no opinion on that. So, but the third way is interesting. My concern, again, is that, it leads you down the road of litigating every single jurisdictional hook where if you just go back to Title II, give it firm legal, give a firm explanation that would survive Chevron deference. Remember, Brand X was a Chevron deference case. All right. And in fact, in the case of AT&T versus Portland, the court said the better reading is the reading that Justice Scalia gave it. So it could go either way, and I think it would be upheld in court.
Great. Thank you, Gigi. So let's talk a little bit about the proper ancillary jurisdictional test for rules. Greg talked about that the action is on the second half of the test, and that is whether the regulation is reasonably ancillary to the effective performance of the agency's mission. American Library and your paper discussed the test as being whether or not it's reasonably ancillary to the effective performance of its statutorily mandated responsibilities. But the commission, in its brief in the Comcast case, argued that its regulations are reasonably ancillary to the effective performance of its objectives or regulatory goals, citing Midwest Video, or United Video case, which argued that it was the protection and promotion of a valid communications policy goal. So different permutations on whether or not the policies stated in 230 and 706 are sufficient to satisfy the ancillary jurisdiction test. Presumably, if it's goals and objectives, 230 and 706 are appropriate bases for that. If it is a mandated responsibility, then presumably they're far weaker. So which is the proper test?
I mean, I think the test that we stated in our paper is the proper test. I think you can imagine why the FCC would rather have the test be focused on objectives and policies as opposed to statutorily mandated responsibilities, because those are the sorts of things that the FCC is left pointing to. And I do think that it also has to be statutorily mandated responsibilities, because what we're talking about here is one rule saying that agencies can only act pursuant to their delegated authority, and another rule being, yeah, that's true, but there's some ancillary jurisdiction out there too. Well, it seems to me the only way for the ancillary jurisdiction doctrine to have a really solid grounding is to get back to the statutorily mandated responsibilities. And I think Helgi put it a nice way when she talked about, look, here's a statutory responsibility we do have. In order to carry out that statutorily mandated responsibility, we have to pass this other rule. And it seems to me that that is much more easily defended as an appropriate exercise of agency authority, even if there's not an explicit statutory basis for that particular exercise.
Well, the presidential answer to Brian's question is that binding D.C. Circuit precedent, which is based on Supreme Court cases that came down after Midwest Video 1, stated explicitly as a statutorily mandated responsibility that has to be pointed to under the second prong.
And 230 and presumably 230 and 706 don't pass that test in your view, of course.
No, they don't.
Well, you have a particular problem with 230 is because, as Greg's paper points out and Helge's brief points out, there's actually language that goes against them exercising authority, saying that the internet should be unregulated, unfettered by regulation. Now, again, I would argue it's not internet. But this is why I started off saying the grounds on which they, on which the FCC puts its, ancillary hooks. It's just not strong. Okay, we can argue about whether it's, a policy would suffice. The FCC certainly argued that. But it's still not strong, and I do have concerns. I'm particularly concerned when it comes to the content arena, that if the FCC has unfettered power under its ancillary jurisdiction, that it's going to start mandating that ISPs or opening the door wide to ISPs filtering content for for copyright infringement. That it's going to get into preserving certain business models for journalism. I mean, so unbounded discretion is not good, and I'd prefer to keep it narrow.
And does your preference for narrowness also extend to, for example, if they try to do universal service under Title I, you would argue that it may or may not work, or if they
That's
try,
right.
or you would may or may not support it, or you believe it would withstand scrutiny?
I just think that everything that people want to do to protect consumers, to promote adoption, to promote deployment under Title I is at risk. Okay, yes, you're right. The Comcast decision isn't probably going to wipe away Title I authority. Period. It's going to take although the FCC had about 7 or 8 jurisdictional hooks that it cited in its Comcast decision. But everything where the FCC might want to protect consumers or promote adoption or deployment is at risk if they do not have Title I authority.
And why is it, Helge, from your perspective, why is it better to go back and do this pursuant to Title I than go to Title II?
Well, first I should say that in that regard, I'm just expressing my personal opinion. We are obviously counsel for Comcast, and my reiteration of our litigation positions is, of course, tied to my client's position. But the flourishes here today are mine alone. And the flourish that has occurred to me is that there is going to be a lawful path for the agency to pursue, regardless of what happens in any of these other proceedings, and then that's being entirely overlooked in this debate. So I'm not saying that that is necessarily a better approach than some other approach. Perhaps it is wiser to seek legislation. As Greg pointed out, the agency would then certainly not have any vulnerabilities on its authority. That would satisfy Gigi's interest in taking care of authority in one fell swoop and not litigating authority on a case-by-case basis. So I actually don't have any opinion on what's better. I just felt that it was important that this other way, the legal use of ancillary authority, was being overlooked in the discussion. We're either running to Title II reclassification, which would overturn a huge amount of agency precedent, or we are seeking legislation, which in some folks' eyes has its downside because it would take time to accomplish that. So it just amuses me often that sometimes the lawful exercise of a particular power is often overlooked in these debates.
Gigi, what about
Brian,
this?
can I just promote? Yeah. I just want to promote. Kevin Warback has a article on some of these questions and does promote a third way. It's called Off the Hook. You can get it at SSRC. We also promoted a third way to try to tie ancillary jurisdiction to the sort of telecommunications component, which to me is the same thing as saying Title II, but it's in our net neutrality comments as well. I don't want to get into a great deal of detail because I do think there's like a sliver of difference between tying, ancillary jurisdiction to the transport component and going back to Title II, which is Title II is just neater and firmer, and that's why we're supporting it.
Well, and actually on that front, that was going to be my question. It's neater and firmer than Title I and ancillary jurisdiction to do Title II. Isn't it neatest and firmest to go back to the Congress and get it all cleared up that way?
Oh, absolutely. I mean, sure it would be better. There's no doubt about it. But Congress can't even get its most important appointees appointed right now. Okay, and in the meantime, while they're doing health care and climate change and trying to get people appointed to the judiciary and to key like public safety and homeland security positions in Congress, consumers are left unprotected. This one will fall down the, yeah, it's obviously the better route. Is it a realistic route? Probably not, just because there are so many unbelievably, and not that this isn't important, all right, but this isn't health care, and it isn't like saving the financial system. It isn't a lot about making sure that our judiciary and our key public safety and homeland security agencies are well staffed.
Oh, yeah.